Welcome to Deconstructing a Master Service Agreement. If you run a service-based business, whether you're a designer, developer, coach, SEO expert, brand strategist, social media manager, email marketing person, etc., you will need a master service agreement, aka a one-on-one service agreement. In this module, we're going to go through a master service agreement one section at a time and the important clauses you need in order to create a comprehensive contract for your business client collaborations. These agreements outline crucial terms and conditions governing services, project timelines, payment terms, and intellectual property rights, among so many other essential aspects. This may seem a little bit tedious at first, but remember in the first module where I told you it's really important for you to understand what you are signing and what is written in your contract? I really meant it. And I want you to be able to go out there and utilize contracts and be prepared with all of this knowledge in your back pocket. By setting clear expectations and responsibilities, master service agreements foster trust, streamline communication, and protect the interests of both parties. You know how we're always looking for those dream clients? Sure, sometimes you get some bad apples and you need to terminate the agreement with them. That's where those tight cancellation clauses come in handy. But most of the time, dream clients come from the boundaries that you create, and those boundaries can be set in your MSA. Let's say you just started your business and you land your first client. You want to go above and beyond for them. They ask for a little touch up here, a little touch up there. You don't protest and you do the work. But after a few weeks, you realize you're starting to really resent your client. You spent so many hours doing extra iterations, making the logo bigger, whatever, and they don't seem to appreciate you or that work that you put in. Are they a bad apple client? I mean, they could be. But also, how tight was the scope of your project? And did you have an additional services clause that clearly stated what the cost of any additional services were so you can bill them for those extra hours at the end? Let's go through an MSA, one clause at a time, so you can see areas that you might be missing, prevent things like scope creep, communication breakdowns, deadline issues, intellectual property right issues, limiting your liability as much as possible, etc. Please note that I have listed out all of the clauses that I think are incredibly important MSAs, but we won't be going through each individual one because that would take an incredibly long time. Our goal here is to go through the most disputed ones. The reason I provided them all for you in this presentation is so that after this class, you can go and check your contracts and make sure that those clauses are included in your services agreements. There are also a few special clauses in there specifically for those that provide deliverables like designers and programmers, as well as those provide coaching and consulting work. All right, you ready to rock and roll? Let's begin. Initial clauses. The first clause is the introduction of parties. This is a bit of a boring area, but it sets the stage for your services. It usually includes things like the parties involved, definition section, and a brief description of the work. An incredibly common mistake usually starts out with using the wrong name. Seriously. You cannot enter a legal contract under your business name unless you are registered as a separate entity such as an LLC or a corporation, not a sole proprietorship. Otherwise, you must use only your legal name. So if you do not have an LLC or a corp, simply put in your full name. However, if you are an LLC or a corp and you sign your name instead of your full company name, you might be personally liable. So if you are an LLC or a corporation, you put your name of your full business name. This indicates that you were representing your business. Same thing goes for signatures. You would put your name, what position you are, such as CEO or founder, and then your company name. Additionally, remember to both sign the contract and to both have a copy of the contract. Another thing to note is if you have a DBA filing, doing business as name. Sign as your full LLC or corporation name instead of that because case law varies state to state or province to province on whether a DBA is valid or not. If you've been doing it incorrectly, do not fear. The court takes into account intention. But do you really need to go through all that hassle? Execution of agreement. This section usually defines that the agreement is effective upon both parties' signatures and also could set up a time limit on when the client needs to sign by. Sometimes clients take a little too long to sign an agreement. This clause encourages them to sign it within a time limit, otherwise the contract is no longer valid. Imagine your start date is only a few months and the client ghosted you after receiving the contract. They then get back in touch with you after a month with the signed agreement that you are now legally bound to, but you've already booked another client into that time slot. This could make for an awkward conversation. So make sure to have time limits on your contracts for when your clients need to sign by. Services. This is where all of that scope creep comes in. Scope of services. This is the clause that outlines all specific tasks, deliverables, and responsibilities that you will perform with your client. You want to make this clause as clear as humanly possible. I've provided a short example about creating business stationery. As you can see, it clearly states a description, deliverables, number of revisions, and what it does not allow for in case the client might think otherwise. Make sure that your scope of services is tight. One of the best measurements in a good service clause is that you have a number before everything. In this case, you can see we are providing the following deliverables customized for 10 people and with only 2 revision rounds. Additional services. This is a really fun clause that I think a lot of people miss out on because not only does it make it clear what your additional services are, but it's also kind of a great marketing spot for an upsell. When your clients read your contract, they can see that you also provide all of these other things. You'll want to make it clear that you have an hourly fee and that you're not exactly bound by the prices above for these additional services, and that both parties will need to agree to these additional services in writing. It should also include that any additional services will modify the delivery date, which is also enforced in writing. Other clauses that you might want to include in a services section are rollover hours. For example, if you offer a retainer agreement and set it to a specific number of hours per month or a specific number of deliverables. Do those hours or deliverables roll over? And what is the math behind that? Because you can always state in those clauses that only a certain number of hours could roll over if unused, or that you have a cap on the number of hours that can be rolled over so they don't all roll over from one month to the next. Then all of a sudden you owe your client 40 extra hours from their unused months. Trust me, it happens. You want to put a cap on that. Client responsibilities is an incredibly fun section to really set your boundaries and policies. Onboarding. This is a space to set appropriate deadlines and requirements for your onboarding process. For example, what happens if your clients don't provide you with all the necessary homework after your initial discovery call? Another clause that's important is communication requirements. You can set wonderful communication requirements such as how long they have to respond to you with regards to information, feedback, or materials. What happens if they do not? And how long will you wait if they ghost you? And what will happen if they do? You can, for example, terminate the agreement and invoice them for any fees outstanding if they've ghosted you for too long. Method of communication. Have you ever had a client who's texting you on one day, sending you an email the next, calling you another, and then slacking you in the evening? This happens to everyone. And honestly, this is because you don't have a communication policy. You can set methods of communication clauses where you state that you only communicate via email and Notion, for example, and set times of day that you do respond. Approval of works. A big part of certain services, especially ones with deliverables such as design or copy or development, are approval of works. In some cases, if clients don't approve works on time, you can't move on with the project. So why not set a concrete deadline on that and state that the clients will be charged for any delays? Or, for example, that they will be forfeiting their revision and you can move on without approval, especially on very tight deadlines. And that they might need to purchase another revision from you from your additional services. Also, something to ponder over and add to your approval of works clause is that what if the client approved the work and then found a spelling mistake once the project was finished? Are you going to fix this issue for free? Are you going to charge your client for the hour of work since they approved the work themselves? And are you liable for this mistake after they've approved the work? Okay, a spelling mistake is a little dramatic, but it could be a spelling mistake on their business card of their name that they've printed 1,000 of already, and they want you to compensate them. Who is liable then? What does it say in the contract? Fees, payments, and expenses. We all want to invoice and be paid on time and also know what happens if our clients don't pay us. A master service agreement can help with that. So, payment of services clause. These outline the terms and methods of payment for the service. So, remember to explain in this section the amount, what currency it's in, whether or not there are taxes, and most importantly, how this client should pay you. For example, it's bank transfer, add your banking details in. Non-refundable retainer, aka deposits. Some don't take retainers, but I highly recommend them for certain services. Additionally, I know you hear the term deposit a lot, and I'm going to tell you, courts favor the term retainer over deposit in contractual disputes. So if you do have deposit written in your contract, go change it now. The reason is in the definition. A retainer is by default non-refundable, and a deposit is payment due date and schedule. This is an important clause to consider wording specifically, especially if you're getting paid in installments or getting reoccurring payments on retainer. For installments, make sure to create a clear list of the amount and dates due or amounts and specific deliverable milestones. And for retainer, make sure to get the date right. Is it the first day of the month, bi-weekly, on the 15th of every month, the last day of the month? Also, please don't state bi-monthly. Select 2 dates in the month because it usually confuses everyone and is very different than bi-weekly, considering different weeks every month. There's a different number of weeks in every month. Rush fees. Rush fee clauses are interesting additions to contracts. I recommend them for all services. Have you ever had a client ask you if you could quickly fit this thing in over the weekend or in the next month or rush a certain deliverable because they all of a sudden needed ASAP? Having this clause means you don't need to think on the spot. You can have a clause that states your flat fee or special hourly rate or whatever fee you choose to put in your contract and tell them it's possible for a price, and that price is in the contract that they already signed. This way, you don't need to think about anything on the spot and you have immediate boundaries set. Late fees. So what happens when your client isn't paying you? Most charge interest, so this section is incredibly important. I've seen some very ridiculous late fee interest numbers on contracts that would never hold up in court. So first of all, in this section, you need to establish how many days does the invoice need to be outstanding in order for it to be considered late. Secondly, you need to conduct some research into interest fees allowed in your country or state. In Canada, you cannot charge more than 60% annual interest, which means that you can only add 5% interest per month. While in the States, the interest completely varies state by state. The next thing you should consider is what happens if they don't pay at all? What can you do? Send them to collections as an option or file for arbitration, etc. So make sure there's a sentence in there that states the client needs to reimburse you for going through those processes. Rescheduling, cancellation, and refunds. This is an interesting area of the contract because you can really choose here what to do in any situation and what happens next between you and your client. Rescheduling. This is where you would set your rescheduling policy. Some companies allow rescheduling projects as long as there's enough notice, whether it's several months or several weeks. Others create hold fees or rescheduling fees. These are fees that the client pays in order to hold their spot for a certain amount of months in which they can then reschedule. For example, your client can pay you a flat fee of $1,000 and you will hold their spot for 4 months. If they can't start the project within 4 months, you keep the $1,000. If you can't start the project in 4 months, you return it. But if they can, you keep it for any service changes or admin changes. Cancellation by client. Think about what you would like to happen if the client cancels the project on you. Would you like the full fee paid in the event of cancellation or paid only the monies owed at this point in time? What if you only just started the project? What happens then? Cancellation by company. Think about what if something comes up and you need to cancel the project with your client? Do you keep the initial monies paid? Do you refund the difference? Etc. Refunds. Do you offer refunds or partial refunds or no refunds at all? These are all really important things to figure out, and they set the foundations of your business. Confidentiality and privacy. Confidentiality. This clause protects confidential information of company and client. This is like a mini NDA agreement within your MSA. Remember we discussed it about coaches having this within their agreements? This is where it's located. Accreditation and promotions. If you aren't completing a white label agreement, you will definitely want to display the final work in your portfolio or on your website. This clause lets the client know that you're going to do so. Testimonials. Your client must agree to share their testimonials. So this is why you should have this clause in your contract. You can't just take their words and put them on your website without them agreeing to it. Website credit. This is important for the programmers out there. If you want to have your name at the bottom of the website to receive a website credit, make sure you add it to the contract so your client knows and also has the option to opt out if they wish.